Good afternoon.
Good afternoon. May it please the court. My Lords, I have taken instructions over the short adjournment on the basis of indications so far from this court. I had identified two different aspects of the application that we have pending in the Lahore High Court. The one aspect I identified was our application for recognition of the res judicata findings in the award. The second aspect was the consequential application with respect to other findings. The interim anti-suit injunction that we are facing is comprehensive. It would stop us from doing anything, in a sense, with this award, including what we say are res judicata findings in our favour. So with that in mind, and with the indications so far from the court in mind, my instructions are that we would be prepared to proceed on the basis of changing the relief we are seeking in Lahore in the following way. Now this, I'm afraid, because it was over the short adjournment, is in the process of being printed out. But can I just explain what the undertaking would be? And that is looking at the prayer. Perhaps we can look at that. That's before the Lahore High Court in the supplemental bundle at tab 3, page 131. Yeah. That would be paragraph 1A1. We would change that so that we would simply be seeking recognition of paragraph 377 of the award. And that's because I've taken you to the findings that we say were made in that paragraph, which we say are res judicata findings, of which we're fully entitled to seek recognition. That would be an application for partial recognition before the Lahore court. We would then delete A2 on the basis that we would simply be in the first of the two categories I've identified, which is we're seeking recognition and we're saying nothing about anything else.
Yes.
And then as an alternative in B, we would change B to give us in the alternative the right, which surely we must have, to seek recognition and enforcement of the full award. And we would have reason
So
to...
I just missed
Yes.
some words: to seek recognition and enforcement of
the full award, simply of the award itself. And of course, we would need to have that flexibility in case the Lahore court decides it doesn't want to partially enforce or recognise paragraph 377. We must be entitled to seek closure and discharge of the award by having it converted into a recognised enforced in Pakistan. And we would then change C, which is the injunction, and limit it to simply a restraint on the issuance of any invoices in violation of paragraph 377 of the award. That, in my respectful submission, caters for the concern of saying saying anything about any other part of the award if the court feels that we're not entitled to do so. But on the other hand, it does give us our right under the New York Convention to have findings which we say are in our favour made into a judgment such that they can be recognised and in Pakistan.
now. This appears, as it were, to be your instructions show that your client is willing to, as it were, slim down the relief that would be sought in Lahore, and so we take that into account when we come to consider the arguments. But could you kindly, at the earliest convenient opportunity, let your colleagues and the court have a paper version
Yes, of course.
of what you've told us, because obviously we've, I think, understood what's being said, but we would be helped to have it in black and white.
Of course. of course.
I must admit, I didn't understand what wording you'd put in A1.
A1 would simply be recognition and enforcement of paragraph 377 of the award.
And you then commented that that would be an application for partial recognition.
The wording is presently recognise and enforce, in particular 514I of the award, by holding that.
Yeah, we would change all of that and not make reference to paragraph 30 hereof. It would actually be a very simple, sorry, I didn't make that clear, a very simple application for recognition and enforcement of paragraph 377.
Of 377?
Yes. And
so you seek recognition of 377 in the alternative, the whole award.
Yes.
And then you'd restrain them from issuing an invoice which you say would be in breach of 377.
So what we're endeavouring to do, maybe I've already said this, what we're endeavouring to do is to hold on to what we say is our right for findings that were made, and there's a utility in that, in having, if there's a contract world that's got to marry with a regulatory world, at least what's been found on the regulatory side is in our favour, and how that marries is for another day, but that we have asked for and got.
So whatever the rights and wrongs of it, you've helpfully, as it were, attempted to specify what you say your rights amount to in a more leaner way than page 131, but without departing from the principles that you've been arguing.
Yes.
Okay. Thank you.
Could they issue an invoice for the NEPRA tariff, and then line 2, balance of contractual sum is X? Could they do that?
I mean, there would then be an argument as to whether it conforms with 377. And that would have an argument to be had when the time comes. But all we're asking for at the moment is wherever recognition and enforcement is sought.
Yes, thank you.
I'm not entirely sure what, if any, assistance I'm going to be able to give the court going forward from that, because you've heard me on many points, but would you let me just cover a few items?
Absolutely. No, it's for you to decide how you want to
thank you.
put it. So, I mean, I don't think, as I've understood it, I don't think that this relieves us of the obligation to have to decide the appeal, even if you now put your position slightly differently. Before you start again, yes, Mr. McLeod, have you had any notice of this?
He is not. No, my lord. No, my apologies.
Do you want the opportunity just to? I mean, you've heard what I've said. I understand the position to be, but it might be different if your position is different. So I'd be perfectly happy to give you an opportunity to briefly take instruction if that is necessary. If it isn't, you can tell me.
We would be grateful for the opportunity. What I may suggest, if I heard my learned friend is planning to finish his submission, and we could have a short break after his submissions in which I could take instructions.
Yes. Well, I was only wanting to accommodate Mr. Landau if anything that he wanted to say was dependent upon anything that you said. So you're about to give us something in writing.
I have in my hand a piece of paper. Yes.
That's a bad start.
I know. Thank you very much.
Thank you. We'll just absorb this.
Yes. It may look like the typo in the last line, but I'm told that is faithful to the original.
Yes. Yes, I think our view is that it would be best if you made any further submissions that you want to make, and then we give Mr. McClure
Of course.
and Ms. Brooke and our clients an opportunity to decide what to do before replying.
Of course, I'm grateful.
Thank you.
I'm sorry that it's well, these are over the shorter term, and these things happen.
No, not at all.
I hadn't given him notice. My lords, my lady, the further points I want to make are really to enforce, firstly, at what we say would be our right still to apply for the limited relief that we're now suggesting.
Mhm.
And then I just want to, if you would allow me, go back to where I was before I changed the menu, and just put this in a bit of
Go back to
context.
one.
Yes.
Yes.
Yeah. Just to put in, and the reason for doing that is simply because I want to, if I may, in my submission, set limits to what this court should and shouldn't do in the context in your convention. That's it. So on the first point, as to our entitlement to seek recognition and enforcement of this, I wanted to address my lady's point early on about how can you get recognition of a declaration or a negative declaration, and the answer is you can. And that goes to the fact that the New York Convention allows for recognition and enforcement. It doesn't make itself any distinction between declaratory relief or non-declaratory or monetary relief, and has accepted that what one's doing by way of seeking recognition and enforcement is taking the benefit of a res judicata finding. That res judicata finding can be in the form of a negative declaration. The reason to do it, of course, is because different systems around the world will react differently to an award or a judgment. And that is the concept often. Recognition is where essentially you're seeking to use something defensively to stop re-arguing of something. And enforcement is a proactive conversion into a judgment followed by execution. Can I take the court, please, back to Professor Vandenberg, which is the Authorities Bundle 4, tab 41, at page 1099. Vandenberg here explains the concept of recognition. If you'd allow me just to read part of this. To conclude this part concerning Article 3, just to pause, to remember Article 3 is a mandatory obligation to recognise and enforce placed upon contracting states. A brief observation may be made in respect of the opening line of this article. It reads, each contracting state shall recognise arbitral awards as binding. And then just dropping down to 3 lines from the bottom, the opening line of Article 3 provides for the basic obligation of a contracting state as far as the recognition of the award is concerned. It must recognise an award falling under the convention as binding. And then if I can just drop down to the next paragraph beginning, the recognition of a foreign award under the convention may occur in a court action between the same parties and on the same subject matter as decided in the foreign award. The defendant may, on the basis of the award, then object to the jurisdiction of the court to entertain the action. It means that the defendant requests the recognition of the award by invoking its effect of res judicata and relying on the principle of nebis in idem in a court action brought against him concerning a subject matter already decided in a foreign arbitration. In such a case, it's not necessary first to institute enforcement proceedings. However, the same conditions as for the enforcement of an award as laid down in Articles 4 to 6 are applicable. The procedural aspects of recognition, such as which moment the award should be invoked for recognition, are governed by the procedural law of the forum. So essentially, Articles 4 tell you what you have to provide to the court, which is a copy of the award and a copy of the arbitration agreement. And then Article 5 on the grounds for resisting recognition and enforcement. Can I then ask you, please, just to turn up the next tab, 42, which is an excerpt from the leading textbook Fusha Gaya Goldman, page 110 of the bundle, paragraph 1667, third line, however, recognition may be requested where the party relying on an award merely wishes to have a negative effect. This was also explained in the context of Section 66 of the 1996 Act, which is enforcement. So,
Exit.
no, actually, sorry, not 1966 Act, but Section 66 of the 1996 Act, and that is enforcement within the country.
Could you just help me about wishing to have a negative effect? Because there's then a reference in the footnote back to Vandenberg.
Yes.
Was that?
It's the same point, which is essentially you're relying upon it for res judicata effect. So you're stopping somebody else from relitigating it.
That's what negative effect means.
Yeah.
Understand?
Yeah. So the case I wanted to show you was the MT Prestige, which is in the Authorities Bundle 3. It is at tab 24. This was an incredibly complicated case involving, well, in fact, I think I would use up the afternoon to go through the facts, but, sorry?
One of us lived.
I know. So, would you allow me just to go to the paragraph that I want? Otherwise, I'm going to spend a lot.
You lived through this particular bit of it.
Right.
That was my choice.
That was your
So everybody's been touched by it, I think, in some way. But so Section 66, there was some observation made in the context of that. So that is not New York Convention enforcement, but it's recognition and enforcement domestically. And the relevant paragraph, there are two paragraphs, 106, which is at page 739. This, I can just leave the court to read that. That sets out what should be familiar territory in terms of how declaratory relief works and how the doctrine of merger applies or doesn't apply to declaratory relief. And then I want to take you to paragraph 117 on page 742. If I could just read that. Although a declaratory award can be enforced for the purpose of Section 66 of the 1996 Act, in the sense that judgment can be entered in terms of the award, that is because the term enforce in Section 66 is not confined to enforcement by one of the normal forms of execution of a judgment which are provided under the CPR, but extends to other means of giving judicial force to the award by recognising it as creating an issue estoppel or as providing a shield against enforcement of an inconsistent foreign judgment. So that's the utility, in a sense, of seeking recognition and enforcement of a declaration. And I think my Lord Phillips would have did come across this in the Infrastructure Service of Luxembourg case in terms of what the notion of recognition is. Yeah, that was, I think, in the ICSID context, drawing upon the High Court of Australia. So the concepts we have in arbitration, which are different to domestic law, are recognition, enforcement, execution. So I just draw the court's attention to that to deal with my lady's observation in the morning, or question as to whether or not you can actually go to court when you've got just a declaration and get anything. And the answer is you can.
Well, are you going to show us authority for proposition that you can enforce a finding in the narrative analysis which doesn't find its way into dispositive decision?
Well, I don't have an authority on that, but I don't have an authority the other way either, saying that it's only matters that find their way under the heading dispositive, which, by the way, is not in every award, that can be recognised or enforced. And that's because, putting it politely, arbitrators come in all shapes and sizes. They draft things differently. There isn't the discipline of a judgment, and in an international setting, there is no principle anywhere to say that the New York Convention is confined to whatever is under a heading dispositive. And what if there's no such heading?
Presumably, it depends on what you interpret an arbitral award to be.
Yes. Well, yes, exactly.
Because, I mean, if to take a ridiculous thing, you, in a 500 paragraph award, you can immediately see problems saying, I'd like to have recognition of paragraphs 21 and 408.
Yes, yes.
So there must be some concept
There's
in
got
arbitral
to be a
awards.
res judicata finding.
Well, I'm wondering whether you're setting the bar for yourself a bit low there. And the fact that something is a finding. I mean, if move it completely away into a domestic context, trial takes place, the judge makes a number of findings. They may contribute in different ways to the outcome.
Yes.
But one wouldn't say that necessarily individual findings were subject to recognition or enforcement or.
Yes, but my lord, that really, I think, is a segue into what I wanted to then address you on, which is what are the limits of this court?
Sorry to interrupt you, Mr. Landau. I'm just mentally processing the submission that has got to be a res judicata finding, which I understand, with the point that you were making before lunch, that not all jurisdictions that are subject to the New York Convention recognise issue estoppel as a concept.
Yes.
How do you square those two?
There's a difference between a res judicata and issue estoppel.
Well, yes.
So most, I mean, every system, I would have thought, and that's why Albert Jan Vandenberg talks about res judicata, will have no difficulty about res judicata. Where the problem comes is on the common law extended concept of issue, well, not extended, the common law concept of issue estoppel, and civil law countries frequently do not have that.
So res judicata would be the bit of the award that resolves what is actually in dispute between
Yes.
the parties,
Yes, yes,
whether or not it's got a heading attached.
yes, yes, yes.
Is it the same as effectively what would or ought to appear in an order at the end of the proceedings, if that's how,
Yeah,
how
but it
things
is
were broken
difficult-
down?
It's difficult to translate, I'm
Yeah.
afraid, the world of arbitration into the, if I can.
So there might be overlay, it might not be identical.
Yes, yes. I mean, frankly, I don't want to
But
give evidence.
it's not just an arbitrator said something here,
Yeah.
then he said something
Yeah.
else there.
Yes, now that is, I think, a link to what I wanted to then just come to, which is what is the legitimate limit of this court's role in answering questions such as that? Because at that point, the danger is, if I can go back to what seems like a long time ago, my conceptual graphic of a page with one line, there's a danger that one side bleeds into the other. And that is that you've got the courts of the seat policing New York Convention territory in New York Convention courts. In the same way as, if the Pakistan court started to interfere in the commercial court in London on the New York Convention application to say, actually, the commercial court can't say when an award is severable, it must be in this way. That's just not permitted. It's not, and that's because the New York Convention is a balance between two different types of jurisdiction that must sit symbiotically together, and it's a quid pro quo. In fact, I will take you in a moment to an authority for that. It's a quid pro quo because courts around the world will accept the mandatory obligation placed upon them by treaty to recognise and enforce, save for very limited exceptions, because they have the say over it, because they have exclusivity.
And when you say this court, again, you're meaning
I mean
commercial court or this
forgive me,
court?
forgive me,
But
forgive me.
in this,
Forgive me, yes.
There plainly is a distinction, isn't there, between a finding which then can give rise to a res judicata and reasoning
Yes.
which underlies that finding, but which in itself might not be
Yes.
capable of being
Yes.
a binding
Correct.
reason.
And we have that because we have it in our English system. Of course, we have that because you don't appeal reasons. But in arbitration, we only have the tools of the law of the seat governing arbitration, and then the New York Convention. When one gets to these kinds of questions, that is, in my respectful submission, the domain of the recognising and enforcing court. And not all courts will necessarily agree on it.
But when you look at 377, the first sentence is simply an agreement that NEPRA's determination is part of Pakistani law. That can't possibly be something that you need the courts in Pakistan to enforce the arbitrator saying what is Pakistani law. That would be
Well, it's
bizarre.
it's still between the parties. It's not open then for the other side to raise an argument later to change their position on this and say it's not actually a matter of Pakistan law.
And then the second sentence, the fact that NEPRA may have incorrectly applied the contract is one thing. The fact remains that this tariff has been published in the Gazette. Well, again, that's an undisputed fact. It's been published in the Gazette.
Yeah.
So you don't want that. You don't want that enforced, do you?
Well, we want the whole paragraph because then it goes on to say that accordingly,
Yeah, any declaration from the sole arbitrator on the tariff could not replace the tariff. Well, he hasn't made a declaration of the tariff, so again, there's nothing to enforce there, is there?
well, we have a right to have that recognised as a matter of Pakistan law, so that if there's any argument later about the disagreement that he has done something, this is a clear statement by the tribunal as to NEPRA's exclusivity, and that's on the regulatory side.
But there isn't any argument about it.
Well, there may be in the future,
Well, that's right.
and that's why we have a right there.
And what I'm not understanding is why the proper approach isn't for you to argue it in the future, if that's put up against you.
Because we have, if it's a finding which is in our favour, because we had argued this, then we have a right to have that recognised. There's nothing to say, well, you can't. I mean, it would be difficult in my respectful submission for the court to rule that we do not have a right to have that recognised. The utility of that will be for us going forward, but to have it actually made, given the force of a Pakistan judgment, is what the New York Convention allows for.
Yes, but you see, you want 377 recognised, but you don't want 380 recognised. Or other concomitant conclusions.
But that should be our choice as to what we put to the Pakistan court. Pakistan court may disagree with us.
But you have to that would have to be severable.
Yes.
Well, as the Pakistan court must take that view. What is severable and not severable, and it may disagree, but that's its right under the New York Convention.
And your submission is that the court in this country there's absolutely nothing it can do about it.
It's not this court's domain.
Yes,
Yes.
that's the same thing.
Yes, but not to say that this court is powerless. It wasn't, for all purposes, because I mentioned New York Convention. That was the point I wanted to make earlier, and it's a discretion point, not a power point. Which is that if the English court thinks that this is an application to annul the award, erga omnes, which only the English court can do, that wouldn't be on its face within the New York Convention. So the English court could act at that point.
But you say if it was an application to annul the award in Pakistan, you can do it even though you're not responding.
I'm sorry, no, I didn't.
You say if it were an application to annul the award in Pakistan, not for the whole world, if that were the truth of what was happening, although I know you dispute that that's what you're doing. But if that were the case, you say you can do that, notwithstanding that nobody's trying to enforce that bit of it against
No,
you.
I haven't made that point, and we didn't make that point in the court below about the right of preemptive action, and that's what we tried to make clear in our skeleton. It wasn't our case before, Mrs. Justice Dias, about preemptive. Our case was only ever, it was consequential upon us trying to seek recognition of the bits which were in our favour. That's so we haven't made that argument, and of course it's not, the word annul is emotive because that takes you straight back into the seat remedies, and that's what all the anti-suit cases are about, is about annulling awards. It's not that, it's about recognition and enforcement in one jurisdiction. But in any event, that wasn't our case. So all I've done now is I've narrowed down the part that we wanted recognition and enforcement of, made it more specific, and jettisoned the other parts.
And perhaps the thing that might, well, we'll see what the appellant says, but the thing that might cause one a bit of concern is leaving in very last line of the relief you're seeking.
I'm sorry, the last line of
Yeah, the relief deemed fit and appropriate by this honourable court may also be granted.
I think it's difficult to stop any party asking a court to exercise its own discretion as to what it thinks is reasonable.
I agree.
And that would be a bit tough for us to be restrained from doing
Why have
so.
you left out the words in favour of the applicant?
In just
In that last sentence.
Yeah, I think it wasn't really motivated apart from trying to simplify this. It just ended up be even-handed.
I just also clarify what you say paragraph 40 means of the application to the done court. Lahore court.
Trying to find it.
Page 130.
That we understand to be the reference being a reference is the reference to the Lahore court. It's not the arbitration reference.
The strange thing is it paragraph 39 refers to the application.
Yeah. But I'm instructed that this is not a reference. It's not the arbitration reference. That wouldn't make any sense. These are, as I understand it, formulas that come at the end to show that the court can deal with this.
Thank you.
Can I just make a few submissions about containing this court's role in the context of the New York Convention? I've described the two spheres, the supervisory court and the courts of the New York Convention. The New York Convention court's jurisdiction is triggered when the rules of procedure are followed. That is Article 4 of the New York Convention, and then the local procedural rules of that country. And that's when that court will be seized. So at that point, and the rules of procedure the Article 4 is pretty simple, the agreement and the arbitration agreement. And then it's made clear that the rules of procedure will govern at that point. And therefore, the balancing that happens is once a New York Convention court is seized, and it's seized pretty simply, it's then that court has got the discretion that the New York Convention gives to it. And in this case, we say that it has been properly seized and it can now exercise that discretion. There are three reasons, if I may submit, why that is then exclusive and why there's no place for the courts of the seat to interfere in the context of a multilateral convention. So this is unlike all the other anti-suit cases where we're not dealing with a convention to which this country is a contracting state. In the other anti-suit cases, it's some other mechanism that seems to be available abroad. That this is one mechanism, one scheme that the UK has contracted for. So the three reasons are, firstly, there is a balancing, very careful balancing between the jurisdictions so that one doesn't encroach on the other. And for that, I wonder whether I can just ask you to turn up the article we put in by Professor Michael Reisman of Yale, Yale Public International Professor, and that is at bundle 4 of the authorities at tab 54. The heading is the control scheme of the New York Convention. That's at page 1192. And if I could just take you to the bottom of page 1194. The reason I'm taking you to this, sorry, I should just pause. The reason I'm taking you to this is this gives you the conceptual, theoretical backdrop to the New York Convention and how jurisdiction was allocated in it. That's the reason I'm doing it. I wonder if I can just ask Your Lordship, Ladyship, just to read over the page to the first part of the paragraph beginning, because international arbitration is an event. So with the word coarchical, which is useful. And then on page 1197, forgive me for asking you to read it, it's probably simpler. 1197, in the bottom of the first main paragraph, there's a sentence beginning, indeed the legal effects, which were actually the sidebarring, if you could read where the sidebarring is.
That's what you submitted to us.
Yeah.
Yes.
And then 1199 is further sidebarring, which goes over to 1200.
Yes.
So thank you for that. The reason, as I say, the reason to put that before the court is just to be, by way of, in a sense, warning that there is a very careful, delicate political relationship that happens in a multilateral convention of this sort in terms of the competing competencies, and they're balanced, and it is a quid pro quo, and that quid pro quo allows for what is a rather unique mechanism of so many countries agreeing to mandatory recognition and enforcement of awards. But they do so because they've got their area as well. And it's not a central command with one state that can dictate to all the others. That is why I have been pulling back whenever possible from this court, laying down its view on, for example, severability, its view of how the convention is to be interpreted on points which are actually the subject of jurisprudential growth in particular seats. So that's the first of 3 points. The second is that the terms of the New York Convention, the express terms, do not give a role to the supervisory court. They give discretion to the recognizing and enforcing court expressly. There are only 2 references to courts of the seat in the New York Convention. One is Article 5(1)(e), which is setting aside as a ground to resist recognition and enforcement. And the other is Article 6, which is a mechanism to adjourn if there are proceedings underway at the courts of the seat to set aside. But otherwise, as I mentioned previously, the convention has in it a simple mechanism to allow courts to be seized. You're seized when anybody asks you to recognize and enforce, and you've complied with Article 4 of the convention. You provide an agreement and arbitration, and the arbitration agreement, and then the local rules kick in. And the last point is an analytically different one, but comes to the same answer, and that is public international law on multilateral conventions. we've set this out in our skeleton, as a matter of public international law, no one contracting state can dictate to another contracting state how a multilateral convention is to be interpreted. There are mechanisms which treaties employ for that kind of thing, such as dispute settlement mechanisms or other consultation mechanisms. And your convention doesn't have that. So it's got to be seen for what it is, which is a multilateral convention where each state is equal and will take its view on the implementation of it. The last area I want to cover, then I would have completed what I want to cover, is in contrast to all the anti-suit cases that the other side rely upon, this is an example of a case where the structure that I have described forms part of the party's contract. Because when you agree, when you contract a London arbitration, you are contracting into the UK's treaty obligations and rights under your convention. It's part of the scheme. So you contract for a supervisory court in London, and you then have, because you've chosen London or England as the territory, you then have, by contract, then your convention territories open to you for recognition and enforcement. That is different from, for example, C versus D, where you are finding a statute in New York that seems to help you and saying, I want to use it because it applies to me. And the English court will say, no, you can't invoke an available foreign statute if that will constitute a breach of your agreement. It doesn't apply to the New York Convention because the New York Convention is the agreement, unless you can show that this is absolutely outside of the scope of the New York Convention in the way that I've described. Because, for example, you're asking for annulment of the award, erga omnes. So there are two aspects to this to distinguish all the other anti-suit cases. This is, in my submission, why you do not have a precedent on this. The two aspects is it's been agreed to by contract, and secondly, this court that is being asked to enjoin the parties itself is a party to this treaty. Not the court as a party, but it's bound by, it's operating within the structure of this treaty. And the agreement here couldn't be clearer as contract. If one just turns up the PPA, it was actually, for what it's worth, it was actually set out, even in broader terms, in the PPA. If I can just ask you, please, to go to the core bundle, tab 9. Paragraph, section 18.3 is the arbitration clause.
Say that again, please.
It's core bundle, tab 9, page 184.
Thank you.
That's where we have the arbitration provisions begin. And I want to take the court, if I may, to section 18.5, which is at page 186. (18.5) is a heading sovereign immunity and jurisdiction. The first part is on sovereign immunity. That's 18, that's A, 1, 2, 3. But if I can take you to B, the following the parties, this is what the parties agreed. The company, which is Star, SHPL, hereby unconditionally and irrevocably consents generally to the jurisdiction with respect to itself and any and all of its assets and property that it now has or may hereafter acquire, of any court of competent jurisdiction for any action filed by the power purchaser, that's my client, to enforce any arbitral award or decision made pursuant to arbitration conducted in accordance with section 18.3. The company waives any objection that it may now or hereafter have to the venue of any action or proceeding brought as consented to in this section 18.5b, and specifically waives any objection that any such action or proceeding has been brought in an inconvenient forum and agrees not to plead or claim the same. Now, it may be that doesn't really take things much further than your convention, but that's certainly an express agreement where the parties they're contracting into it, and indeed Star is waiving any objection to the fact that there will be an enforcement phase. And that will be for the forum where enforcement is sought. and there won't be arguments against that structure.
Well, that's an agreement by your client.
So in this, it is Star is the one that's actually making this agreement.
I see. Star is
Sorry, the company is Star. My client is Power Purchaser,
Yeah.
ACDC.
Yeah.
So that's what distinguishes in my submission this case from the anti-suit ones, where somebody is coming along and doing something which is breaching the arbitration agreement or the contract. This is not. What we're doing here is we've invoked a court abroad, but it's a court that was always on the radar in the contractual bargain. And it's because of that that we say many of the questions that this court has put to me about when can you sever, what are the circumstances for recognition and enforcement, how do we apply the New York Conventions, not for this court. Within the scope of the contract between the parties, it's been allocated to wherever enforcement is happening. And that's not cutting across the supervisory jurisdiction of the commercial court. It's not undermining it. Calling it an attack on the award in that way, I mean, I think we've gone beyond that anyway, but that's really where I wanted to start before I change the menu, is that there are defined spheres in the New York Convention. Remember, this is an application for an anti-suit injunction only on the basis of breach of contract, not vexation and oppression.
Just help me with one last question, which is, I'm sure is very obvious to you, just to clear my mind. Let's suppose in this case, with these terms that you've been referring us to, there was a much simpler award which simply said, you pay them $1 million, whatever. Does your analysis lead to the proposition that it's open to you to go to, let's say, Pakistan court and issue the application that you've issued in terms saying we make an application in effect for non-recognition of that award?
I haven't made that argument.
I know you haven't made the argument, but I have at the back of my mind that that's what your argument amounts to.
So I've been careful to the argument is put in a way that it doesn't amount to that because we're asking for affirmative relief ourselves.
But I know, but the right that you're asserting, if it's anything, seems to me to be the right to do that. But I'm giving you the opportunity to correct that because you might say, well, no, I couldn't do that because.
Well, firstly, that's not the right we're seeking. The right we're seeking is to have the findings in our favour put in a form that will be of utility to us as we're entitled to on your convention.
No, at the moment I'm using a counterfactual situation where instead of the nuances that are in this particular award, you simply had the most clear possible award, which was on any view adverse to you. As I'm understanding your argument, you're asserting the right, as you've repeatedly described it, to go to Pakistan and invite them not to recognise it. That must be what your argument amounts to, isn't it?
This is a point which is specifically, do I have a right under the New York Convention to act preemptively? That's the question. Do I have a right under the New York Convention to act preemptively?
Yes, but I'm not concerned about the preemptive aspect of it at the moment. I'm concerned with the nullifying aspect of it. And I'm understanding, quite possibly misunderstanding, the implications of your argument. I appreciate you've been careful not to state it in those terms, but I think once one understands what you're arguing, that is the consequence. I mean, you may be right, but that's the consequence. You're right. You can do what you want.
Well, you definitely do have the right to do it. That's what Article 5 says.
Yes.
The question is whether you can do it preemptively.
Exactly.
Yes.
Exactly. That's what. Sorry, forgive me. I wasn't unclear, but that's the point. And that point has not actually been very clearly decided anywhere. There are views that the convention doesn't, in its wording, doesn't appear to allow you to do that. And then there's another argument, which is it's very strange because it's really form over substance. Because you're giving the right to the other side simply to say yes or no whether you can make the Article 5 arguments. If the court does it of its own motion, it's fine. If somebody...
So the reason is because, as you say, there are 170 and the only basis upon which the jurisdiction of any one of those jurisdictions is engaged, save for the supervising court, is if somebody wants to enforce in that jurisdiction.
Yes.
Otherwise, you could trail around all of those jurisdictions seeking preemptive orders, and that can't be right.
Yeah, and I mean there may be. At this point, it's not live actually, and there'll be arguments on both sides of it. There is that possibility. The counter to that is that that's not very different from people chasing assets around the world and different courts taking different views anyway, because each court under the York Convention, like it or not, is restricted to its own territory, and therefore you get a patchwork if courts are saying things differently, unless there is issue estoppel.
So are you saying it's not live because of the amendments you've made, or not live?
Well, it's certainly what we say wasn't live anyway because of what I've made that point already. But it's certainly not live now because we're asking for what we're entitled to, which is simply the positive side. And I should emphasise we're also asking in the alternative for full recognition enforcement, so we can get clarity, discharge the award if the court is not amenable to 377.
Thank you. Thank you. Now, Mr. McClure, Ms. Perrick, would you like a short break now?
Yes, please.
The completely different room in the mansion. I'd also like you, if you would, to take the opportunity to discuss together the situation with any note or transcript that's being made of this hearing, because I think our view is that this is something that needed to be raised with the court before embarking. I don't want to make an issue about it unless we have to, but I think we have some concerns about a note being made off the live stream and then possibly being produced elsewhere as a transcript when it isn't a transcript. And so there may be a practical solution which would involve whatever is produced being shared, including with the court. And there being an understanding that it wasn't going to be used externally without permission of the court. But I think it's a matter for you to discuss, and I just don't want to leave it to the end of the day when you haven't had a chance to think about it.
Grateful, my lord. We will discuss.
Very well. Well, shall we allow you 10 minutes in the first instance? But if you want another 5, you can ask. Thank you.
You know, that's what we need from that. It's still
I'll just hang outside and they pop up. This is not. I'll just hang outside until we. It does say this bit.
Yeah.
Which suggests it's not just
Yeah,
what's in the
yeah.
dispositive, you have to figure out what it is.
Yeah, yeah. Yeah, I'll remind you that if we come back to that.
Sure.
Yeah.
You spoke to them?
Hi.
Mark and Kit speaking to their solicitors. The solicitors. So presumably Mike will explain it when he stands up.
Okay with that.
No, we're ready.
Yes, Mr. McClure.
May it please court. First point to make is we don't accept that amending the prayer in the hearing like this is the way to proceed. If the respondent wishes to reformulate its claim in Pakistan, the correct course of action is either to withdraw the current claim and reissue a new one. And we would ask for the court at this point in time to proceed to deal with our application for an anti-suit injunction, which is made in relation to the Lahore proceedings that are before us for the reasons that we've put out in our submissions. The Lahore proceedings are impacting my client, and so we ask for them to be injuncted for the reasons.
So the way it would work out is you want a decision on the appeal as constituted, that if you were to succeed in getting an interim injunction, then it would be theoretically open to the respondent to approach the court in this jurisdiction seeking a relaxation of that injunction on the basis of a change to the its litigation elsewhere. Is that how it would work?
Yes, or to the extent it has new claims that are not within the scope of the injunctive proceedings. They're not prohibited forever from commencing proceedings in Lahore. So if they had new claims to phrase in a new way, and they weren't caught by the injunction, whether interim or final, that you were to issue, they would be free to pursue those. Or if the new claims that they wanted to pursue were caught by any order that you were to give, then
I wasn't so much talking about a new claim. I was talking about as it were, the reduced claim as has been presented to us. As I understand your submission, the way that you argue that should be dealt with is by them doing that by proper form in relation to those proceedings, or at least saying what they would exactly do.
Yes, my lord. We would further submit that we don't think the reduced and reformulated prayer is satisfactory either, and is going beyond the scope of what the respondent is entitled to do. These submissions have obviously only been formulated in the short break that we have, but we would say in relation to point A, it is not open. Whilst we do accept it it is in theory possible to seek partial recognition, enforcement. We've never denied that. We would not say it's open to seek partial recognition enforcement specifically of this paragraph in those terms.
What, because it isn't partial recognition?
Yes, my lord. And in that regard, I would like to direct you to the transcript of the first instance hearing. It's in the supplementary bundle, tab 11. And what I'm going to take you to is Ms. Parrick's submissions, and she's quoting from the English case of AZ v BY. The case isn't in the bundle now.
Page?
It's 272.
Yes.
And Ms. Parrick's quoting two paragraphs from the decision. We can provide the decision to the court, but she's quoting first from paragraph 17, noting that while the form of arbitral awards varies, a format adopted by experienced legally trained arbitrators generally follows a conventional format, which will start with some formal paragraphs, contain a long narrative, following out the tribunal's findings, and then its conclusion on any issue law between the parties before reaching conclusions based on the application of the law as found or agreed to be applicable, will lead the tribunals to its conclusions and to a dispositive section in which the tribunal sets out the sums awarded and other remedies granted as a result of the relief. Then in paragraph 18, the court says, I agree with BY submissions that where such an approach is adopted, the section of the award that commences the tribunal hereby decides and awards as follows is likely to, and to have intended by the tribunal to, contain and to be read by a reasonable person with all the knowledge reasonably available to the parties, to be the reference as being a comprehensive statement of what an English court proceedings would appear in the order following a trial. And this is all the more likely to have been what was intended when the curial law of the reference is English law, as it is here, and at least a majority of the arbitrators are English lawyers. And
that follows Bank Mellis and GAA Development Construction, doesn't it?
Yes.
It's just a stain.
Yes.
Just so you know, that case, I think, is now known by its full name, Nigeria LNG and Talaverius, and is on appeal.
The point for now is we say it stands for the proposition that you can't just pick and choose parts of the award. And so we would question whether even in the time available that we've had to formulate these submissions that the prayer A would be available to the respondent. Similarly at B, seeking a prayer for the court to pass judgment to order and recognise the award against itself. This is similar to the floodgates argument that you have alluded to, my lords and my lady. And in relation to...
Would you submit, Mr. McLeod, that there's a power to stop a party from asking any tribunal that's a New York Convention state from recognising an award full stop generally? I mean, you may get an award that has got some findings in favour of a party and some findings against a party, but in principle, how can this court stop someone going to a New York Convention state and saying, I want you to recognise the whole of this award? Maybe a bizarre thing for them to want to do if they're the losing party, but I don't see how you can stop them.
Well, my lady, in our submission, we'd say you should not be able to enforce an award against yourself.
Yeah, well, that's why I used the word recognition as well. You obviously can't enforce a award, well, you wouldn't want to enforce an award against yourself. But if there's declaratory relief in an award, let's take a hypothetical case that's different from this one. Let's suppose that you've got two parties who are each arguing about different things that the contract means, and the arbitrator finds in favour of one party in some areas and in favour of the other party in another area. It may well be that because the findings are also interwoven that you can't sever. Is there anything wrong, in theory, at least, with one of the parties that's got 5 points in its favour and 3 against, going off and saying, I want you to recognise this award as a whole? It seems to me, provisionally, that that's what the convention allows, and I can't see how that can be restrained.
No, quite. I think we would accept that.
Well, I think that the discussion started with the proposition that somebody was asking for the recognition or the recognition of enforcement of an adverse award and not a mixed award. And I imagine in that situation, the court might look very closely at what was going on because it would be sufficiently peculiar that it would listen to argument about what was happening here.
Yes, quite, my lord. And it goes back to one of my earlier submissions this morning, that the role of the court seeking to injunct or considering injuncting is to look at the full characterisation of what is being done in the foreign court.
And what you have here is what is being proposed by way of the revised prayer is A, B, and C. So they're not just seeking B.
Yes.
C may well actually be the real gem of it.
Yes, and we would have objections to C as well for reasons that have been aired already. In particular, if there is a dispute in relation to invoice. First of all, that whether or not paragraph 377 contains any finding in relation to invoices, and secondly, if there was a dispute in relation to invoices, that would be a dispute under the PPA that should be resolved via the dispute resolution mechanism in the PPA. So my primary point is that the way to deal with the problems in the existing Lahore proceedings is not to amend them on the hoof now in the hearing, and we continue with and we ask the court to issue the anti-suit injunction that we've sought in the application, and further we have concerns with how the revised prayer has been formulated for the reasons I've set out.
Can I be clear? Are you inviting us to say that we should pay no attention to this and ignore it?
Yes, my lord. Initially, yes. We would say the task before you is to rule on the injunction application relating to the Lahore proceedings as they stand currently. And
the trouble about that is, if we did that, then you may well find that there will be an application to the commercial court to vary the injunction to allow them to amend to plead this, because it won't have been determined. If we don't deal with it, as you said, it will be open to them to.
Oh, my apologies. I think I misunderstood your question, my lord. Our primary position is that you should ignore it, but it is open for you also to deal with it. It doesn't, the possibility of reframing the Lahore proceedings should not impact your decision as to whether or not you are prepared now to injunct the current Lahore proceedings. But we would invite you to comment upon the we would invite you to comment upon whether that you considered the amended pleadings as set out here to be satisfactory.
Well, because we're always so anxious to get to the heart of things. I mean, this is I don't say this critically, it's what's happened. It's a change of case. In the middle of an appeal, so far as this court is concerned, it's not pleaded. There's no respondent's notice in relation to this. There's no application for fresh evidence in the terms of a change of position. I mean, I think all of these matters feed into your argument that you can't chase a moving target, and that if the respondents were unsuccessful on the appeal, it doesn't arise if they're successful, then there are remedies that are open to them. And by coming to change the injunction, but what we are entitled to take account of is the arguments that we've heard, and depending upon what we think about them, to express a view about them, and they may or may not encompass the new version. I mean, it might be that they wouldn't. It would just deal with the case as it was before the judge. It might be, on the other hand, that our conclusions of law did encompass the new version, and obviously you're not able to say where that might end up. But I consider, if I may say so, that the respondent was right to, as it were, say what their position was. But I think telling us, and it being a pleaded matter on which we can reach a conclusion, is something we'd have to think about.
Yes, my lord, I think that's, I wouldn't put my submission any further or higher than that. I'm grateful for you putting it in a neater way than I would.
There is one other thing, which is there is a draft order in the bundle which appears at 64. It's of some antiquity now, 6 months ago. If you were successful, is that the order that you're seeking, or is it some evolved version? There's some formal things that need dealing with, but is there a more recent version of the order that you seek from this
There's no
court?
more recent version, so this is still
Is that definitive?
the order that we're seeking.
Yes, I mean, I have to say for myself, I haven't read it, so I just want to know, before I take the trouble to read it, is it the document which, if your appeal succeeded, you would invite us to follow? Of course, apart from the formal parts, does it have the core of your plea in it?
Yes, it does.
Well, this is what you were seeking for the judge.
Yes.
That's what you've appealed from. So
Yes.
it must be.
Yes, I mean,
Yes.
I'm maybe being a bit plodding about it. I just wanted to make sure that there isn't something else that has happened that would mean that it was no longer apt.
No, nothing has happened since, my lord, so this is the order we seek.
Right, is there anything else on the appeal? By way of reply, I appreciate that your reply has been rather focused on the new issue. Is there anything else you want to say on the appeal itself?
Just two, possibly 3 points on the appeal. just in relation, so 3 points, 3 short points. First, you were taken to the textbook of Albert Jan van der Berg, which is D4 tab 41. I'd just like to take you to a couple of other provisions in relation to that. My learned friend took you to the paragraphs that is sidebarred, starting on page 1103 over to 1104. And while it's sidebarred in his submissions, he stopped at the end of the first substantive paragraph on page 1104, ending in the word arbitrator's findings. And the Lord and Lady, I would just direct you to the next paragraph, where he is saying that the assertion that the arbitrator has misinterpreted facts or law is not a defence under the New York Convention. And on a similar theme over the page, at paragraph 1105, again in the paragraph that's sidebarred, but starting 9 lines from the bottom, where it notes that the division of judicial control over the award as provided by the convention is such that if a party desires to challenge a badly reasoned award, he should go to the courts of the country in which the award is made and there request setting aside of the award.
Well, the first sentence is helpful to you, isn't it?
Yes,
In
my
the
lady.
form of examination as to how the arbitrator is which is beyond the task of the court before which the enforcement of the convention award is. So that seems to sever the responsibilities between the two jurisdictions. One is dealing with the making good the decision, enforcing the decision or recognising it, and the other with how he got there, or she got there.
Yes, yes, my lady. And then I said I had 3, actually only have 2. The other point I would just like to direct you to concerns the doctrine of choice of remedies. My learned friend gave the example of a piece of paper with a line down the middle, and you can have, you can decide to take action in the court of the seat, or you can decide to take action in the court where your adversary seeks enforcement. And in our submission, that is right, in that there are 2 options. There is not a third option to preemptively raise Article 5 defences, and there is English authority for this. If I could direct you to the case of Dalla and Pakistan, A214, page 398, and it's the judgment of Lord Collins. Starts at the bottom of the page 398. Consequently, in international commercial arbitration, a party which objects to the jurisdiction of the tribunal has 2 options. It can challenge the tribunal's jurisdiction in the courts of the seat, and it can resist enforcement in the court before which the award is brought for recognition and enforcement. And these 2 options are not mutually exclusive, which is the point that my learned friend was making. But my point is that these are your 2 options. There's not a third option. And that principle is set out, perhaps, is set out a little more fully in the Court of Appeal decision in Dalla and the judgment of Lord Justice Ricks. That's in the same tab, but at page 355. And there, Lord Justice Ricks is quoting from Mr. Justice Kaplan in a Hong Kong case of Paklito Investment. And I would just ask your lordships and ladyships to read the quotation starting just after C and going to the letter F.
Letter
F.
okay.
We would submit also, my lords, my lady, there's similar dicta from the courts of Singapore, and that's PT First Media, that's Authorities Bundle 4, tab 32. And in particular, paragraph 65, which is page 957, oh sorry, page 973.
Sorry, tab.
Tab 32.
Thank you.
And it's commenting about the model law here, but the judgment notes that, quoting from the analytical commentary on draft text of the model law, that the application for setting aside constitutes the exclusive recourse to a court against.
You're reading from paragraph
65.
Thank you.
Against the award in the sense that it is the only means for actively attacking the award. A party retains, of course, the right to defend himself against the award by requesting refusal or recognition of enforcement in proceedings initiated by the other party. And then it goes on in 66 to quote about the application for setting aside constitutes the exclusive recourse to a court against the award in the sense that it is the only means for actively attacking the award. Party retains, of course, the right to defend himself. Oh, sorry, I'm reading the same
This
quote.
just comes from Article 5, though, doesn't it? That's the
Yes.
wording of Article 5.
Exactly. And if you needed another authority on that, I won't turn it up, but Mustel and Boyd at paragraph 17.247, which is Authorities Bundle 4, tab 49, page 1179. And just finally, sorry, I do have a third point. In relation to the submission about the submission to your lordships and your ladyship that you should tread carefully in relation to any decisions about interpretation of the New York Convention. In our submission, it's not open to my learned friend to take that point. His submission is, as I understand it, that the contractual regime within section 18.3 of the arbitration clause in the PPA, which includes with it the incorporation of the New York Convention. And so his submission is that he has a contractual right to invoke the jurisdiction of the New York Convention. If that is right, my lords, my lady, you have a contract, you have the right to interpret the convention as well. Unless I can be any further assistance, that concludes my submissions. Before I sit down, I have a short point in relation to the transcript that I could update you on. But in terms of my submissions there included, we are endeavouring to get you a transcript as quickly as possible. We don't yet have more of an update than that, but perhaps to assuage your fears about where the transcript will come from, I misspoke earlier when I suggested that the transcript would be coming from the live stream. It will be coming from the official court recording.
I see. Okay.
In the usual way.
In the usual way.
Yes.
Oh.
But that can take weeks.
It can take weeks. I believe we've got it down to 1 week, and we are endeavouring to get it to shorten that even further.
Well, exactly the same thing was recently said in the Nigeria and Talaveras case, that we'd have the transcript in 1 week. We didn't.
I will endeavour to make sure that is not a repeated experience.
Thank you, Mr. McClure. Mr. Lano, there were a few cases mentioned at the end. If you wish to respond in relation to them, you're welcome to do so. I think I see where they fit with your submissions and Mr. McClure's, but they weren't mentioned before. You're entitled to.
I mean, there are. I don't think there's anything I need to add at this point. Actually,
It's all within the frame of the argument.
Frame and the same points we made.
Very well. Well, we're going to rise now for a short while. Please don't go far.
Court rise available?
Yes. This is the part where we go in prayer.
Leave Anya in here to come grab us. Yeah. 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 Are you okay? Are you okay to stay and then when? Sorry. Are we okay to go leave someone in here to come and get us? Come back in. Is that okay? Thank you very much. Anya. So I think it's Anya, that's
Sorry?
that's okay. The clerk said that's okay. So when you're told, you have to run and get. Do I have to ask for it now? So we're quite new. of course. We help with this one. Yeah. So we wait 20 days. Oh, I see. So not the books.
You do 360 appraisals. That's the worst they could say about you. I think you're doing okay.
They're outside the room. Do you want to unlock the room whilst?
The room is not open. It's locked.
Yes, Kate's got the key.
Okay.
You got the key. That's what I'm saying. Yeah.
But we should probably get that. Yeah, we'll miss it if it's just gonna open on that. Thanks, kid.
Okay, 2 minutes. Oh, 2 minutes. Okay.
they sent us into.
We thank you all for your assistance and the arguments that we've heard today. Given the issues which arise, we will obviously need time to consider our reasoning. However, it's a case in which it's important that the parties are aware of the outcome as we find it to be, which is that the appeal will be allowed. And we will, as of now, make an interim injunction in the terms of paragraphs 1 to 5, accompanied by the penal provisions as appear in the draft at page 64 to 66 of the bundle. That order, unless you wish it to be, need not be drawn up because it will only last a matter of hours. What we propose is that the parties submit an agreed draft order by noon tomorrow to our clerks. That will give you an opportunity to put it in full order and to reflect on the terms. The draft that we see that was presented to the commercial court will be the starting point. But if there are any matters which arise in relation to the drafting, please give short reasons why you're not agreed about them. And we'll then make an order as early as possible tomorrow afternoon, which will be the final order arising from the appeal. As I say, we will reserve our reasons, and the amendment to the rules in the Supreme Court allows us to say that the time for appealing runs from the receipt of our draft judgments. That, I think, yes, the time for asking us for permission to appeal runs from the time of receipt of draft judgments. We will probably insist upon an early reply, but it leaves open the route for further appeal if that should become appropriate. Clearly, we will attempt to provide you with reasons as soon as we reasonably can, and in that context, it would be of assistance to the court if the transcript of today's hearing was made available to it. Mr. McClure, is there anything else that arises?
Just one short point. The draft order in the terms of paragraphs 1 to 5 obviously doesn't include costs.
Yes, it doesn't include costs. You can wait till tomorrow for that. It just seemed to us that it wasn't particularly satisfactory that we told you that the appeal was allowed, but that there was no relief over a period of an overnight period, that it was appropriate that there should be a holding order until you're able to agree the terms of a final interim order in draft.
Grateful for that.
And as we've said, we're not encouraging you to go back to the drawing board. We're asking you please to start with the draft that was provided to the judge, because in all fairness, that ought to be the menu for an appeal. Is there anything you'd like to raise, Mr. Landor, in closing? No, well, thank you very much, and thank you all. Yes, I should, sorry, it must become a rather extended passage that when you get our draft judgments, as you would all be very well aware, they will be under embargo. They'll be under embargo until we've signed them off, and your contributions will be very welcome in matters of editorial corrections, typos and the like, not further argument. And we won't need to trouble you for the return. The judgments will be handed down electronically. Thank you.